to the individuals. Where are they? They're sitting, I guess, seated now, who have firsthand experience with the harms of forced arbitration. I appreciate your willingness to share your stories. Thanks for doing that. Nearly 8 years ago, just 5 days into my new job as senator, I attended my very first hearing of the Judiciary Committee. It just happened to be Justice Sonia Sotomayor's confirmation hearing. So I knew that was a really big deal, and I was honored to be there, and it was a little intimidating, but I was very honored. And when it finally became my turn to speak, and I was last, of course, because I had just gotten there, what I said essentially was that I said, I think this is a pro-corporate activist Supreme Court. But I knew then what has become more abundantly clear over the past 8 years. In one 5-4 decision after another, we've seen the Roberts Court go way out of its way to answer questions not before it, to overturn precedents, to strike down laws enacted by Congress, and to do all this at great cost to consumers, to workers, small businesses, and middle-class Americans. And in no area is this bias more obvious than when it comes to forced arbitration. In Concepcion, in Italian colors, the court effectively reshaped the Federal Arbitration Act really into a permission slip for corporations to opt out of the civil justice system. From nursing home contracts and employment agreements to credit card and cell phone contracts, corporate America uses forced arbitration clauses to restrict Americans' access to justice by stripping consumers and workers of their constitutional right to have their claims heard in a public court of law. Instead, they're forced into a private justice system that is inherently biased toward corporations. Remember that corporations can write the rules in arbitration proceedings. Everything can be done in secret, without public rulings. Discovery can be limited, making it hard for consumers to get the evidence that they need to prove their case. And there's no meaningful judicial review. So there's not much a consumer or an employee can do if the arbitrator just gets it wrong. It's just not fair. So my colleagues and I have worked long and hard to reverse this wrong, and today I'm introducing my Arbitration Fairness Act, which would prohibit the use of mandatory pre-dispute arbitration agreements in consumer, employment, civil rights, and antitrust cases. This bill gives Americans a real choice. If a consumer or worker wants to take his case into arbitration, then by all means he is free to do so, provided that the corporation is also willing to do so. However, if the consumer or employee wants to go to court, then that option will once again be available to her. While I will continue to push this bill and support the legislative efforts of my colleagues here today, I refuse to forget exactly what got us here, and I'm looking forward to my next opportunity to question a Supreme Court nominee. American consumers and workers cannot afford another activist judge on the bench. They can't afford a judge who hides behind originalism to side with big business over everyday Americans. Now, I will turn this over to our first guest, former Fox News anchor Gretchen Carlson, who hails from the great state of Minnesota. Yes, thank you. Gretchen, really appreciate all you've done to put the light on this issue of forced arbitration. In July of 2016, Gretchen took on one of the most powerful men in the media, Roger Ailes, suing him for sexual harassment. The world took notice, and 2 weeks later, Ailes was forced out of Fox News. And because of your advocacy, because of your courage, because of your strength, other victims of sexual harassment have been able to come forward. So thank you. And I believe that it is in no small part because of you that other corporate cultures of gender bias have recently been unearthed. So thank you again for all of that, and thank you for joining us today. Please welcome Gretchen Carlson.
Well, I'm so pleased to be here today to join this effort. As you may know, Senator Franken and I, both from Minnesota, what you may not know is that we appeared together a couple of years ago on Celebrity Jeopardy. He beat me, but if he gets help from both sides to pass this bill, I guess I can forgive him. Little context about why I'm here today. About 30 years ago, our courts recognized that sexual harassment is a form of illegal sex discrimination. But since then, unfortunately, we've made little progress. Yes, many companies require all of us to go to sexual harassment training, and our employees are told that the workplace is safe for them. Still, over the last 9 months, I've found out that sexual harassment remains pervasive in our culture. And it turns out almost every woman has a story. I plan to change that. I never expected to become the face of this issue, but once given a mission, I rarely back down. Part of my inspiration has come from my communications with so many women across this country. After hearing my story, they felt comfortable to tell me their stories, many for the first time. I've spent months encouraging them to find the same bravery that I did, to take a stand and to say enough is enough. Just in the past week, we've heard over 100 women at Sterling Jewelers, and numerous women in Silicon Valley are joining the legions of us who've been harassed, discriminated against, assaulted at work. The floodgates are opening. And still, so many other women are still being silenced by employers who force employees into the secret corporate system called arbitration. By forcing women to be silent about illegal and abusive behavior which causes them much pain, in many cases, the employer is able to leave the abusers in the workplace to harass again. The arbitration process, often argued to be quicker and cheaper for employees, instead silences millions of other survivors who may have come forward if they knew they weren't alone. Let me be very clear. This is not a partisan issue. Republicans, Democrats, and independents are all sexually harassed. The harassers come from all political parties as well. There's a lot of division in our country right now, but on this issue, we are all Americans. Americans who believe that victims of harassment should not be forced to give up the rights guaranteed by the 7th Amendment to our Constitution, which guarantees all citizens the right to a jury trial in an open public court. No one starts a job expecting to get into a dispute. I know I didn't. We start new jobs with hope, not fear and concern. So the argument that victims of harassment agree to give up their constitutional rights when they sign a contract is ridiculous. Employers are insisting that employees give up their rights in order to have that job. I bet tons of people here today, or tons of people who will watch this, have no idea if they have an arbitration clause in their employment contract. Do you know? Harassment is not only damaging to women and their families, it also hurts businesses. Men are distracted by abusing women who are not fully doing their jobs. Women harassed cannot perform at their best. Maintaining a workplace of harassment and discrimination is bad for the bottom line of any company. So let's make a pledge. Let's work together to end this. Let's take it out of the shadows of secrecy. Let's be a voice for the voiceless. Let's end the practice of employers forcing harassed women into silence through forced arbitration. Together, I believe that we can speak up, stand up, and I plan to evoke change. Thank you.
Thank you.
Now, Senator Dick Durbin from Illinois. Dick?
It's an honor to be here with my colleagues, and let me particularly thank Gretchen Carlson and Al Franken, our Minnesota twins, for bringing us together, along with the...
Tell Amy that.
I won't. Corporations and the politicians who serve them hate courts and courtrooms like the devil hates holy water. They're scared to death of what a jury might do to them if average people can hear what they have done to others. And so they hide these arbitration clauses in every contract, as Gretchen just alluded. And people find themselves precluded from a day in court, precluded from telling their story to ordinary Americans in the hopes that justice will be served. It comes in so many different forms. We've heard about sexual harassment. The bill that I am going to reintroduce today is called the Class Act, and it really focuses on just another aspect of this. It relates to for-profit colleges and universities. There are three numbers which I want you to remember because they'll be on the final. 10. 10% of all high school graduates go to for-profit colleges and universities. 20. 20% of all the federal aid to education goes to these schools because they charge so much for tuition. 40. 40% of all student loan defaults are students from for-profit colleges and universities. Why? They're so darned expensive. The diplomas they hand you are so worthless. Students get debt piled on top of debt, and they end up being literally defrauded, most of them seeing their lives changed forever. Well, you think, eventually those schools will have to answer for their conduct. They don't, because of mandatory arbitration clauses. The students cannot stand together in court against these schools. And sadly, losing that option means that they're faced into individual resolution of their cases, and many of them give up and walk away, mired in debt, with their lives changed forever. The Class Act changes that. For the record, you don't have to worry about finding that at Georgetown University, University of Illinois, University of Minnesota, D-Conn, or any of the major public and private nonprofit universities across America. It's only in one industry because it's more business than education. And that's why I think the Class Act should be added in. I'm happy to join with Al Franken into an effort at so many different levels to finally get rid of mandatory arbitration clauses.
Thank you, Dick. Sheldon?
One of the things that we in the Senate see is the infiltration of corporate influence throughout so much of government. And I want to thank Al Franken for bringing us together on this particular exercise of it. Thank you, Gretchen, for your putting a spotlight on the problem of mandatory arbitration. And I'm very happy to be here with my fellow Rhode Islander, Congressman David Cicilline. You see in the appointment of a Wall Street guy to Treasury, in the appointment of a polluters guy to EPA, and the appointment of a for-profit education person to the Department of Education, a visibly wiggly tentacle of that corporate infiltration, but it really permeates. And the Supreme Court's role in this has been profound, dramatically expanding the right of corporations to take away the Seventh Amendment rights of human beings, and in contracts where the human really has no choice to force them into mandatory arbitration. As Dick said, there's a reason for this. Corporations exert their influence throughout Congress, throughout the regulatory agencies of government, throughout the executive branch of government. The one place they can't touch is the jury. They try to influence every decision maker that they can, and they often succeed. But trying to meddle with a jury, it's a crime. And the jury is always new. So you can't go and find out who the jurors are going to be and go do nice things for their brothers and go threaten them that if they don't behave, you're going to run opponents against them and play all their usual schemes. The jury is the place in the Constitution that was designed to equalize power between individuals who have very little of it and individuals who have a lot of it, who have great power and wealth. And so clearly, they don't want to be in front of juries. They want to inhabit the corners of government where they can exert improper and undue influence, and they do. Imagine gun cases that didn't reference the Second Amendment, and think how peculiar it is to see Supreme Court jury trial cases that take away people's right to a jury that don't even reference the Seventh Amendment. So I'm glad to be here with all my colleagues. We are going to contribute to this effort a bill that will take away the ability of corporations to force, where there's a public health and safety concern, mandatory arbitration and that thus secrecy. Perfect example, a homeowner who has leased their land to a fracker and suddenly finds out that their water supply and that of their neighbors may be endangered, but is silenced by mandatory arbitration. This is a really important issue for the civil rights of all human beings against the corporate power that so dominates this town, and I'm grateful to be a part of this effort. Thank you.
Thanks to our great colleague, Al Franken, and to others who have gathered with us, not only from the Senate, but also from the House, and to Kevin and Gretchen, fellow Greenwich resident, proud to say, for being here and putting a face and voice on this problem, which is often hidden, because the whole point of these clauses is to cover up discrimination and sexism, such as Gretchen saw countless women and men see, and the world just saw at Kay Jewelers in the most recent cases that she cited. There is a larger issue here, which is that our nation is potentially at risk of losing fundamental rights and liberties. The bulwark against the threats that we see all over are, number one, our free press, which continues to stand up to bullies and to the kind of coercion that otherwise would happen. And the other is our courts, which most recently struck down an unconstitutional immigration ban and will continue to provide that kind of bulwark against overreaching and dictatorial assumption of power. And in the courts, we are all equal under the law. We are all equal before the jury, but also before the judge. And the important thing about these clauses is they lock the courthouse door, not only to juries, but to judges. They prevent people from having their day in court. And these secrecy clauses force victims to remain silent, forbid them from having a day in court, but also from giving light and voice to the problems that they encounter. And that's why I'm supporting the Mandatory Arbitration Act of 2017, but also in an especially egregious example of discrimination and enforced silence, our veterans are often victims of exactly this kind of practice. That's why I've supported and introduced a second bill called the Justice for Service Members and Veterans Act that will protect veterans like our next speaker, Kevin Zer. Kevin is a Navy reservist who was fired by his former employer, after he informed the company that he would be deployed to Afghanistan. He filed suit under URISRA when he returned, but his company forced him into private arbitration. Now, two of my sons have served, one in Afghanistan in the Marine Corps Reserve, a tour that he did and then returned, and another is currently deployed in the United States Navy. I'm on the Veterans Affairs Committee. I see this problem all the time in reservists as well as veterans who are deployed. Their job is supposed to be kept for them, and often, fearing retaliation, they are intimidated into not reporting violations of these laws. In a ruling on Kevin's case, the Ninth Circuit stated, quote, "We acknowledge the possibility that Congress did not want members of our armed forces to submit to binding coercive arbitration agreements. That intention, however, is not expressed in the statute itself or in the legislative history." We need to make clear that is our intention. That is what we as legislators, as the United States Congress intended, and we want, and we will insist on having for everybody in the workplace, but most especially veterans who serve and sacrifice and put their lives on the line for freedoms exactly like this one, a day in court and simple justice. So Kevin, if you would please share your story.
Good afternoon. As a reservist, a combat veteran, and private citizen, I want to sincerely thank Senators Blumenthal, Franken, and other members of Congress for your efforts to protect the rights of workers and service members from arbitration agreements that take away our constitutional rights. The issue of arbitration has become very personal to me. In July 2010, I was hired as a manager by BLB Resources, a federal contractor in Irvine, California. From 2010 to 2012, I helped BLB grow from 18 employees to over 90. About 6 months into my employment at BLB, I was required to sign an arbitration agreement as a condition of keeping my job. Like other employees who needed their job to make ends meet, I felt I had no choice but to sign the agreement. In the fall of 2012, I received active duty orders to deploy to Afghanistan for 12 months as a reservist. I immediately informed my employer that I would soon be deployed and I wanted to return to my job after my military duty was over. I felt confident this would not be a problem because of the Uniformed Services Employment and Reemployment Rights Act, otherwise known as USERRA. Since the 1940s, federal law has guaranteed reservists the right to take military leave and return to their civilian jobs after their military duty is over, and USERRA is the latest law to provide those important protections. On my last day of work at BLB, I was greeted by my colleagues with a standing round of applause. My office is decorated with camouflage netting and balloons, and there were cards and gifts stacked on my desk. At noon, my employer held a surprise party for me in my honor, where 40 of my coworkers gathered to wish me well on my deployment. There was even a large cake decorated in red, white, and blue with the inscription, "Best wishes, Kevin." Around 4:45 that same afternoon, I was summoned into a meeting with BLB's Human Resources Department, where I was summarily fired and told my position would not be available to me upon my return home. The shock of learning I was being terminated from my job on the eve of my deployment to a combat zone created an unimaginable amount of concern and anxiety about how I would earn a living when I returned home. No service member who is asked to fight for their country should ever need to worry about fighting for their job when they return home from war. When my deployment ended in the spring of 2014, I was further surprised when I filed a lawsuit to enforce my federal rights under USERRA. I was surprised because BLB's arbitration agreement did not mention anything about USERRA claims. I was also surprised because when Congress enacted USERRA in 1994, it expressly stated service members cannot waive any right or benefit under this law, and that arbitration cannot be required. But before my case could be heard by a federal judge, BLB Resources invoked that arbitration agreement, and the district court said I was required to arbitrate USERRA claims. I appealed that ruling to the Ninth Circuit Court of Appeals, but they also held I would be forced to arbitrate my USERRA case, a ruling in direct contravention of the intent of Congress when it enacted USERRA. USERRA is one of the strongest federal civil rights laws in both the substantive and procedural rights it gives to service members. For example, service members can file suit anywhere in the country where their employer is located. They can't be charged fees and costs, and there is no time limit to file a claim. But arbitration agreements routinely take away these rights. And even worse, arbitration agreements silence the voices of veterans and service members by forcing them to confidentially litigate their cases behind closed doors. Later this month, I will ask the U.S. Supreme Court to hear my case, not just for me, but for the millions of American veterans and service members whose service is made possible by USERRA and who are protected by this law. I hope that the Supreme Court will hear my case and uphold the original intent of Congress protecting service members against arbitration agreements. At the same time, Congress can and should pass legislation to fix this problem. I'd like to thank Senator Blumenthal and Franken for introducing bipartisan legislation to clarify that service members and veterans cannot be required to arbitrate their claims. I also like to thank the more than 30 national veteran service organizations that have called on Congress to enact this vitally important legislation. Today, Senator Franken and other members of Congress have also introduced the Arbitration Fairness Act, and I hope that there will be strong bipartisan support for this bill as well. Too many workers are required to sign arbitration agreements and give up their rights to simply get a job or keep their job. I know firsthand how difficult that can be. With the Arbitration Fairness Act, no worker will be forced to choose between waiving his civil rights and providing for his family. Thank you for this opportunity.
I just want to say, Kevin, thank you so much for your service. And I'm going to, I don't know whether we've started it yet, but I'd like to organize an amicus brief in support of your petition for certiorari and invite Senator Franken to help lead it with me as a fellow member of the Judiciary Committee. Even though he's not a lawyer, I know.
That was unnecessary to say.
But I always love being his straight man. So.
Thanks. Hank?
Thank you, Senator. Good afternoon, everybody. I'd like to thank all of my colleagues and the guest speakers today. Kevin and Gretchen, your stories are poignant, and they serve as real examples of what forced arbitration does to working people of America of all stripes. And it doesn't matter what party you are, you can be victimized by a forced arbitration clause. You all delivered a powerful message today. And this week, we find ourselves fighting a series of House bills representing the goal of systematically stripping away the rights of hard-working, law-abiding citizens to hold multinational corporations and other wrongdoers accountable and responsible for even issues like fraud and sexual abuse and harassment. Forced arbitration is an extension of those efforts to undermine our rights. They've been undermined in both the legislative branch and also the judiciary. Buried in the fine print of everything from cell phone contracts to your Uber account. These clauses bar you from taking your case to court for a jury trial when you've been hurt or harmed by the wrongdoing of others. The massive sex discrimination case against Jared K. Jewelers is the latest example of victims being forced into this rigged and secretive process known as forced arbitration. 9 years ago, a handful of brave female employees were required to use arbitration unsuccessfully to address sexual abuse, pay disparity, and gender discrimination claims, but they were barred from speaking about it during the pendency of that arbitration process, which is ongoing. Only last week, as part of that case, which involves 69,000 women, they've finally been able to share their stories, but unfortunately, after almost a decade, their cases are still trapped in forced arbitration. I'm proud to once again reintroduce the Arbitration Fairness Act, which I first led in 2007. It will eliminate the use of pre-dispute forced arbitration clauses in consumer, employment, and civil rights cases. The Arbitration Fairness Act, H.R. 1374, was filed this morning. It protects Americans from being forced into arbitration and preserves our Seventh Amendment right to a trial by jury. The bills on the floor this week in the House, to the contrary, combined with a multitude of legal challenges in response to the Trump administration's ill-conceived policies, remind us how important it is to maintain an open and fair access to our legal system. I'm proud to stand with my colleagues today as we fight back against this Republican-aided corporate abuse of the men and women of this country, and with that, I'll yield.
David?
Rhode Island. Good afternoon. I want to begin by thanking Senator Franken and Senator Leahy in particular for their leadership and my colleague Congressman Johnson for his leadership. We are all here because forced arbitration is wrong, plain and simple. It stacks the deck against American workers and American consumers, and it rigs the system in favor of corporate special interests. And we saw two incredibly powerful examples, and I want to thank Kevin and Gretchen for sharing your story and using your voice to help right this terrible injustice. These clauses, as you all know, are often buried in the fine print of contracts. They shield corporate misconduct from public scrutiny, and they're used to block consumers, workers, and victims of discrimination from getting their day in court. As Justice Ruth Bader Ginsburg wrote in 2011, they have deprived consumer rights to seek redress for losses and insulated powerful economic interests from liability for violations of consumer protection laws. The Supreme Court has found that forced arbitration clauses in contracts can even override rights established by federal and state laws. This is outrageous, and the practice absolutely must end, and we need to empower people to vindicate their rights rather than facilitating corporations from extinguishing those rights. And that's why that I, along with Senator Leahy, today introduced the Restoring Statutory Rights and Interests of the States Act. This bill will ensure that consumers' rights takes precedence over forced arbitration agreements that benefit big business. It empowers the American people and ensures that their rights are protected in a very fundamental way. It guarantees that they don't unknowingly give up their legal rights. And the topic, as Hank mentioned, is especially timely today because later this week the House will consider a series of Republican bills that make it almost impossible for American workers and American consumers to take on big corporate special interests. It's time for us to say no more. And the introduction of this package of bills is really going to help send a very strong signal that it's time for all of us to work on behalf of working Americans to restore the rights that we all hold so precious and that are embodied in our Constitution. Thank you.
Brad? Thank you, David.
Hello, I'm Brad Sherman from California's best named city, Sherman Oaks. I want to thank Gretchen and other speakers for illustrating the fact that it's not just the victim who's hurt by these imposed arbitration provisions. The provisions are used to create secrecy. That secrecy means that other victims don't come forward, and it means the victimization continues. Now, last December, Senator Sherrod Brown, ranking on banking, and I introduced the Justice for Victims of Fraud Act. This is a narrow bill, and it's going to be hard to explain why, once again, Republicans will not even give us a hearing on this bill, because it pits ordinary Americans against Wall Street. We all know that 2.1 million phony accounts were created at Wells Fargo, another 560,000 phony credit cards. Now, the harm is not just the fees imposed on the card or on the account, because what happens is you're unaware of the account, you don't pay the fee, Wells Fargo reports that to the credit rating agency, and you don't get the mortgage. Now Wells Fargo comes forward and says, maybe we'll give you back the fee that we wrongfully imposed on the account that you didn't open. Wells Fargo goes further and says, if you legitimately opened an account and signed an arbitration clause with regard to that account, we will apply it to the accounts you didn't open, the arbitration provisions you didn't sign. Now, if you want to have some fun on my YouTube page, I've got CEO John Stumpf. I took about 6 questions for him to admit that that is Wells Fargo's position. Now, Stumpf resigned in disgrace, but the disgrace continues under new CEO Tim Sloan. That's why we're reintroducing this year the Justice for Victims of Fraud Act. We have 18 original co-sponsors in the House, including the ranking members of Judiciary and Financial Services. And in the Senate, Sherrod Brown, again, ranking on banking, has 18 Senate co-sponsors. Unfortunately, we do not have a Republican co-sponsor. And I think it will be difficult for the Republican Party to explain why they side with Wall Street over ordinary crime victims. And make no mistake about it, We're talking about 2.1 million crimes: bank fraud, forgery, identity theft. So with us today, we have a man who's a crime fighter, a man who does emergency dispatch for the Fort Worth Police. Talk about a crime victim: phony account, phony credit card, $1,300 in phony fees, sells to a third party the right to collect the $1,300 they made up, then ruins the credit of the person that they victimized, leading to a denial of a mortgage and a chance to enjoy the American dream. Aaron Brodie, come on up.
Good afternoon. My name is Aaron Brodie, and as he said, I'm an emergency dispatcher for the Fort Worth Police Department. When I was starting college in 2011 in Bakersfield, California, I went to my local branch of Wells Fargo there and opened up a checking account. Even though I had told the representative of the bank that I only wanted the checking account, he opened up a credit card with my name without my permission or any signature. Later, when I received the credit account in the mail and the card, the employee told me, I called him and told him that I didn't want it, that I'd never authorized it. He told me, go ahead and throw it away or don't use it, and there'll be no repercussions. There'll also be no consequences. You can just get rid of it and nothing will happen. I followed his instructions and I destroyed the card and thought that had solved the matter. I was wrong. Every time I had used my debit card, a charge, if it went over the amount, I was charged fees to fund that card, to the Wells Fargo credit card. About a year after opening the account, I received an invoice from Wells Fargo saying that I owed them just under $1,000. I was shocked and horrified. I went back to the same Wells Fargo branch to dispute the charges, and Wells Fargo basically said they couldn't verify that I had not given consent or that I had given consent, as the employee who had worked there and who had established that account was no longer with the company. When I refused to pay these charges, Wells Fargo reported them to the credit reporting agencies. This greatly hurt my credit score, lowering it by nearly 125 points. This has impacted my life in many ways. I've had to make larger down payments. I've had to pay higher interest rates on car loans. I'm unable to qualify for a mortgage because of the fraud that Wells Fargo has done. Even I've had to go as far as hiring a credit repair company, which has cost me an additional $2,000 out of pocket. Wells Fargo has refused to make things right for me, and it turns out that I'm not the only one, because millions of fraudulent accounts were opened by Wells Fargo and their employees around the country. The only way that we'll be able to achieve justice is through the courts. I've recently joined a class action seeking to hold Wells Fargo accountable for their fraudulent activity. But Wells Fargo is trying to force me and thousands of other customers to opt out of the courts and go into secretive arbitration proceedings. There I'd be forced to go it alone instead of being in a public courtroom with thousands of other customers who were similarly impacted by Wells Fargo fraud. Fortunately, there's something that we can all do, and that can be done about Wells Fargo so they don't get away with it. I want to thank the senators and the members of Congress that are here today and introducing their bills and discussing their legislation that will help protect American consumers like myself and the others affected from forced arbitration, and fighting to protect the rights of ordinary Americans to hold powerful corporations like Wells Fargo accountable for all their wrongdoings. Thank you.
Aaron, Kevin, and Gretchen, thank you for your courage and thank you for sharing your stories. My name is Donald McEachin. I'm the new member from Virginia's 4th Congressional District. Up until December 31st of this year, I was a trial lawyer. And so I understand the power of a jury. I understand how juries usually get it right. And if they don't get it right, there's an appellate process that does get it right. What is the common theme that you all have heard here today? First of all, that there's a Seventh Amendment right to a trial by jury, not just in criminal trials, but also in civil trials. It is a right guaranteed by our Constitution. And what's happening here is that there's this notion that you learn in law school, contracts of adhesion. That means that the contract is put in front of you and people don't have equal bargaining power, like in credit cards, like in employment agreements, like in leases. It's take it or leave it. You don't like it, too bad, you can't have the service. That's not right. And that's where we find these arbitration agreements. We're not talking about Exxon and Shell trying to negotiate something and putting it in arbitration. Those are people of equal bargaining power. We're talking about unequal bargaining power. And that's where everyday ordinary Americans are being taken advantage of. And so that's why I'm glad to join with these members here in putting forth these bills and in fighting back on this really assault on our constitutional rights. Now here's the argument that I would suggest is really the probative one, and that is, do the members of Congress trust their constituents? Because you know what? Our constituents make up our juries. And if our constituents are wise enough to send us here to Congress, even those who are on the other side of the aisle, to make decisions dealing with war and peace, spending billions upon billions upon billions of dollars, then surely they are wise enough to sit in a jury box and decide between two parties what is right, what is wrong, and what in fact happened. And so those of you who are going to lobby on behalf of these bills, at the end of the day, ask the congressman, ask the senator, do you trust your constituents? Because if you trust your constituents, you don't mind them sitting in that jury box and figuring these things out. If you don't trust your constituents, then yes, of course you will oppose these bills and you will continue this assault on the 7th Amendment. Thank you, Congressman. Thank you, Senator.
Thanks, Congressman. I'm Patrick Leahy from Vermont, and I'm listening to Aaron Brodie, and I wish you were the only person that happened to. Not because of you. I wish it hadn't happened at all. But unfortunately, as you know, there are hundreds and hundreds more, and that is wrong. It was wrong for you. It's wrong for the others. And hearing the congressman just speak, I began my legal career as a trial lawyer. And we'd have cases like this. You'd say, okay, there's been an injustice. If we can't settle it, let's go to trial. We take our chances. We'd assume you had a fair judge, impartial judge, and you'd have a fair and impartial jury. That's not here. If you have a mandatory arbitration clause, guess who's going to win? Especially when you get down to the print that's so tiny, nobody could read it. And this directs consumers, workers, seniors, veterans, families in every state. Now, it's an outrage. Wells Fargo has been mentioned many times. I'm sure they're delighted to hear their name mentioned so often. But they use these forced arbitration clauses. Why? They were hiding a fraudulent scheme. They created sham accounts. They allowed this to go on for years. Think of all, Mr. Brodie, think of all the other Aaron Brodies across the country. They could care less because they knew they'd win. And that's why, thank goodness you're standing up. Gretchen Carlson, outraged she was prevented from discussing her allegations of sexual harassment against her former employer. No one should be precluded from discussing sexual harassment. If you can't discuss it, if it has to keep hidden, when do you think it's ever going to stop? Is that correct? You can't let companies be allowed to push Americans out of court and behind closed doors. No company, no matter how big, no matter how wealthy, no matter how powerful, can't say, we're going to push you out of court, we're going to put you behind closed doors, and then you've had it. That's why I'm reintroducing the Restoring Statutory Rights Act again today. I'm joining Senator Franken and others in the reintroduction of the Arbitration Fairness Act. And I agree with all of you. We are to have this and trust the American people, not the one side that wants to win every time. Let's make it fair. I'll take my chances in the court system. I've argued cases there. I know what it's like. I'll take my chances there. I'm not going to take my chances behind closed doors based on page 38 of a contract that nobody's seen. Thank you.
I want to thank Aaron and Kevin and Gretchen especially, and all my colleagues. And we're going to open it for questions now. If any members of the press or anybody has a question, all of these are the same story, basically, which is Americans unable to take advantage of their Seventh Amendment rights to go to court. And in every one of these cases, well, in every one of them, it's a corporation, has exercised its mandatory arbitration clause in order to have this decided in private, so that the information doesn't get out. So in the case of sexual harassment, that they want to keep that a secret. And well, okay, and then we got a question, so.
You've seen how these big TV networks doing bind their employees into these arbitration clauses. Do you sense that affects the way these places cover or don't cover arbitration as an issue, or more broadly?
That's a really good question, and I suspect that it may. Did Fox really highlight your case? I mean, did Fox go like, you know what this is? This is about mandatory arbitration and how corporations do that. I think in this case, of course, that broadcast network didn't highlight it, but it may actually, you know, this is something that is pro-corporate. This is where, and one of our members spoke about contracts of adhesion. Arbitration is fine when there are two equal powers that enter into a contract. But this is about little people getting exploited by corporations. So I would think that, yes, we don't see a lot of stories about this issue on television. They did
But
one.
we expect a big one in the Washington Post.
Oh yeah, but that's right.
I don't agree that arbitration is fine when there are supposedly equal parties, because even if it looks like they're equal, often they are not, and the party that seems to be equal doesn't realize what the clause actually says.
And could I add just that as we're in the old well, a whole lot of us been trial lawyers here, but it Senator Blumenthal and the others know, if you have a right to go to trial, if you have a right to go to court, now an awful lot of those cases didn't get settled, and usually you work out a pretty good settlement because you know you can go to court. There is absolutely no incentive of a company like Wells Fargo and others to settle if they know that 99 times out of 100 it is so cranked in their favor in arbitration that they're going to win. Why settle? Why settle? Just sit there and wait them out. But if you're going to court, if you know you can go to court, and they may have a jury that might clobber you, well, let's sit down and talk about a settlement. And that's what happens.
But we're looking forward to that, the piece you write.
On the front page.
We really are. With
You got one in the back, Senator.
above the fold, I'm sure. Yes. Well, they tie in that we've had agencies, the CFPB looked at mandatory arbitration and the abuse of it and made some regulations to protect consumers. This is a Consumer Financial Protection Board. And, you know, my first bill, actually, it was the second thing I got passed in the Senate, was so that military contractors couldn't use forced arbitration in sexual harassment, in violations of civil rights, and wrongful imprisonment. So there are areas where in the CFPB we hope can continue to write these kinds of rules so that there'll be financial institutions who can't do that to Aaron.
It's my understanding that the rule would apply only to future problems, future contracts, so it wouldn't solve the problem here. And we'll have to see whether the Republicans will bring it up for the Congressional Review Act when the regulation's published.
All right. Anybody else? And you guys are free to go. I'll just hold the fort, but you can stay because you're a lawyer, and that'll help. Yes.
Our President Donald Trump has used arbitration in his business dealings in the past. So are you confident that if this were to pass out of Congress that he would sign it?
Yes. Thank you.
Very confident. Absolutely.
Very confident. Thank you all. Bye.
Enjoyed it. Senator, very nice to meet you.
Good to see you. This is Congressman. Now, where's your home?
Richmond, Virginia.
Richmond, Virginia.
Yes, sir.
My son-in-law was born